Hi, thanks for using my court call. I'm Sarah and I'll be your instructor today as we talk about the bifurcation of status of marriage or domestic partnership form FL-347. As with all our court forms, you want to fill in your identifying case caption information at the top. If you are using this form, that means that you have requested to bifurcate the marital status and terminate it early. And that request has been granted. A termination of marital status needs to be included in a judgment, so you would want to attach this to an FL-180 judgment form, so mark the box that says attachment 2. Below that, mark the box that identifies your role to this case, whether you are the petitioner or respondent. And then below that, you're going to list the date that your marital status terminates on, or your domestic partnership. Below that, it states the court finds that you complied with your preliminary declaration of disclosures requirement and that every retirement or pension plan that was to be joined to this case has been joined unless a joinder was precluded or made unnecessary by applicable law. Then the court states that it needs to make one of the following orders regarding each retirement plan that is joined. Either the court is making a final determination of the division of that retirement plan and are dividing it, or they are making an interim order just stating that each party's right to those retirement plan benefits are preserved, or they're making a temporary order awarding one party a 1/2 interest of the retirement benefits, and that's just to preserve those funds until a final decision can be made. So for each of the retirement plans that have been joined to this case, you want to list the name of the plan and then identify which of these 3 orders above the court made with respect to that plan. If you need more space, you can add an attachment to this form. And then line 3C indicates that the moving party, the party that's requesting the joinder and has been granted, or not requesting the joinder, but is requesting the bifurcation of status and has been granted the bifurcation of status, must serve a copy of this judgment on every single retirement plan or pension plan administrator. When we were going over the form FL-315, which is the request for a separate trial, we indicated that there were certain orders that the court would have to make. And so this next couple pages is in alignment with the orders that were listed on the FL-315. And this, again, only pertains to a bifurcation of marital status. So you want to mark the box that says division of property, and then mark the identity of the party that the court held has to indemnify and hold the other party harmless from, and then the different boxes that mark these sort of adverse consequences that the other party could face as a result of the early termination of marital status. With health insurance, you want to list which party has to maintain the existing policy. And again, that party, it should be the same for here. If at any time during this period the petitioner or respondent is not eligible to maintain that coverage, so it would be the same party for both of these, then that party must obtain comparable health insurance coverage so long that it is available. And if it is not available, then the court made an order identifying which party would be responsible for paying for those uncovered health and medical costs to the extent that it would have been covered by the existing insurance plan. Line C has to do with the probate homestead. The court will make an order that indemnifies, and that one party must indemnify and hold the other party harmless from adverse consequences if the bifurcation results in a termination of the other party's right to a probate homestead. So mark the box that the court found must indemnify and hold the other party harmless. Same goes for D, having to do with probate home allowance. Whichever party has to indemnify and hold the other party harmless you need to mark the box that correctly identifies that party. And same with C, the court will have made an order that one of the parties must indemnify and hold the other party harmless from adverse consequences to the other party if the bifurcation results in the loss of the other party's right with respect to retirement benefits. So again, mark the box that correctly identifies the party that has to hold the other harmless. And same with F. This one, actually, you don't even need to mark the box. It states moving party must indemnify and hold the other party harmless. And then G, if the court makes any specific orders regarding non-probate transfer assets, then you would need to include an attachment that includes that specific order and mark box G. If the court makes an order that the division of the IRAs is going to be ordered to be preserved to defer distribution of the community interest upon the death of the IRA owner, then you would mark the box of who the party is that has to defer distribution. It's going to be the moving party. And then on page 3 of 3, if the court makes any other orders to enforce community property rights pursuant to Family Code Section 2337 CG, and that has to do with the request for a specific security interest. If the responding party is able to prove that that is necessary and the court agrees and makes that an order of the court, you would want to attach a document to this form that explains what that order is specifically. And then any other orders that the court makes that it believes are just and equitable, you would mark box 5G and describe what those orders are. There are a number of attachments that we've referenced as part of the preparation of this attachment to the order. So tally those up, write in the number of pages attached, and then this form is ready to submit as part of your judgment. I hope you found this helpful. Good luck.